Cuomo has been summoned to appear in Albany City Court on November 17th, but the former governor has not been officially indicted. That determination will ultimately be made by the Albany County District Attorney. And get this, the DA's office said it was unaware that the complaint was being filed today. So where does this leave us? Joining us now is Todd Kaminsky. He is a New York State Senator serving as a Democrat. He's also a former Assistant District Attorney. Todd, thanks so much for coming on the show. Really appreciate it. All right, a lot to unpack here. So first of all, where are we right now in this case legally?
Well, I think what happened was that the document that was filed in court that perhaps may not have been public right away, but was revealed, kind of shows where this is going. And that is that a summons is going to be issued for the governor's, for the governor to come into court to face a criminal charge. Now, what you just brought up about the district attorney not knowing it was filed today is the key word, because I would be shocked if the Albany district attorney did not work with the sheriff's office to be ready to bring this complaint. Of course, a sheriff's office or law enforcement could file a complaint on their own without the DA, but it would be highly unusual and really, I think, poor practice to drop a case on the DA's lap without the DA working with you from the beginning, ready to accept it and move forward with it. So I think that word today you used, Dan, is key. I think the DA was ready for this and will be ready to prosecute this case. The question was whether today were they ready for it to be filed publicly.
Well, so the DA is saying on Twitter that he learned about this like everyone else when this was made public. Said he didn't know that this was coming. But I want to read you, because I'm going to get to that in a minute with Aaron Keller, but I want to read to you from the statute, because I think that people may be under the false impression that this is going to be pretty easy to prove. And the statute is as follows. A person is guilty of forcible touching when such person intentionally and for no legitimate purpose forcibly touches the sexual or other intimate parts of another person for the purpose of degrading or abusing such person, or for the purpose of gratifying the actor's sexual desire. Now, we saw in the complaint that they used language that almost mirrored that, but that's not an easy type of case to prove.
Well, you are correct about that, but this case takes a whole other dimension and really raises the stakes, because I cannot imagine a world where the former governor does not try to take this to trial and try to discredit the accuser. And first of all, I just have to back up and say that I give the victim here a lot of credit for coming forward with this. This is going to be highly public. I do think the sheriff believes her. They've corroborated to the best they can her account, and they're ready to go with this. And as someone who's prosecuted former public officials, I prosecuted a Congress member, a Senate Majority Leader. When you bring cases against someone like that, of that level, you have to be ready for a war. It can't be, oh, we'll do some of it now and do some investigation later, or maybe they'll take a plea and we won't have to be put to the test. You have to be ready to have all of it put through withering scrutiny. And in this case, with the best attorneys that money can buy in a public court. So this is going to be, I think, a protracted legal drama, even though it's just a misdemeanor. And I think there's going to be withering scrutiny brought. But I think that, what the sheriff's office is telling us today through their actions is they believe they're ready for it. They believe the victim, and they're ready to corroborate it and bring it into public view.
Now, the former governor has responded. His attorney, Rita Glavin, has made a public statement saying, quote, Governor Cuomo has never assaulted anyone, and Sheriff Apple's motives here are patently improper. Sheriff Apple didn't even tell the district attorney what he was doing, but Apple's behavior is no surprise given, one, his August 7 press conference where he essentially pronounced the governor guilty before doing an investigation, and two, his office's leaking of grand jury information. This is not professional law enforcement. This is politics. Do you think that now the DA is going to be under political pressure to move forward and file this case regardless of what the legal determination is?
So I still don't think we know how much the DA was involved in this investigation at all. It could be none. It could be. It would be highly unusual not to be. But if this was really dropped in the DA's lap, the DA has to do real investigation. You cannot bring a case as a DA ethically if you don't believe that that the charges are there beyond a reasonable doubt. You obviously have to believe the victim. You have to believe that a crime was committed, and you have to be willing to take that to a jury. That's the bottom line. Now, of course, in many cases, many that I prosecuted, the defense wants to impugn the motives of the government. And that really depends on how much a judge is going to let that in. But at the end of the day, it comes down to whether the jury believes the victim and whether there's corroborating evidence supporting her charges.
But again, the challenge here is that you have to be able to prove not just that it happened, but that the person did it with the intent of degrading or abusing such person for the purpose of gratifying the actor's sexual desire. That is part of the statute, part of what they would have to prove in court here, which I think that's the part that, again, is going to be a challenge if this goes to trial.
There's no doubt about it. And remember, the public knows some of the allegations from the Attorney General's report with other victims. In other words, when you view this as a pattern about what he might have said and done with other young women, that might seem a little easier to prove, but it's far from certain that evidence could come into trial. And that's something that's going to have to be legal.
And that's a great point, because I would bet that in the context of this case, with this evidence, that a judge probably will not allow evidence of other, what we call other bad acts. It has to basically be similar enough in nature that it shows a pattern of conduct. I don't think the judge is going to allow that in. So I guess my point here is I think people are underestimating how hard a case this is going to be, regardless of whether you think it happened. I think that the proving it in court is going to be a real challenge here. And let me do this. Let me bring in quickly Aaron Keller. He's an attorney, senior editor for the Law and Crime website, which I founded. He's been tracking the allegations closely against the former governor. He's got some fascinating insight tonight in an article that he wrote on the Law and Crime website. Aaron, you wrote in your article that the sheriff has used here a rarely used procedural mechanism which allows him to go straight to the court and not through the DA. Talk to us about that.
Dan, this was such a rare situation that several experienced, seasoned attorneys in New York State that I talked with when preparing the report basically said that they were shocked that this procedure was even used. But I do have sources that walked me through it and said, look, it is possible in this sort of situation with a misdemeanor information where the sheriff can do basically exactly what he did here, where he gets his officers to go to the court and the court issues a summons for the defendant to appear. And that's what the sheriff said happened here. This process is a stark departure from what we normally see in New York State, which is where a law enforcement officer writes an appearance ticket. And then the person is given a couple of weeks to show up to court and, other booking procedures are done at that point. So this is very procedurally awkward. It's very different from what most New York people, even seasoned New York people, are telling me that they usually see in the Empire State. So the question is, why did the Albany County Sheriff Craig Apple take this specific tactic in this case? Why did he go around the DA's office? We don't know the answer to that, but we know that's what he did.
Well, and Aaron, we know that the DA tweeted out, like the rest of the public, we were surprised to learn today that a criminal complaint was filed in Albany City Court by the Albany County Sheriff's Office against Andrew Cuomo. And so that suggests to me that you've got a real problem going on here between the sheriff and the DA in the case against Andrew Cuomo. But let me do this. Let me take a quick break here. Senator Kaminsky, Aaron Keller, stick around because we're continuing to cover this. One of the questions I still don't understand is why aren't more people covering this? I mean, I was looking up on cable news when this broke, and I was thinking, why isn't this everywhere? And yeah, there was a little mention of it here, a little mention of it there. But why isn't this a bigger deal? Is it because of this sheriff versus DA? Anyway, take a break, come back in a moment. Thank you for watching. Click the red subscribe button below so you can get more of NewsNation's fact-driven, unbiased coverage.